Good morning, colleagues. It's the appointed time and we've already formed a quorum. Thank you very much for attending the Bills Committee meeting on Product Eco-Responsibility. It's the 13th meeting, and let's invite the administration team to join us. Welcome back. Happy New Year. We hope that we can complete our scrutiny of the bill as soon as possible. And to save time, while we were in our break, we received a response from the administration with regard to their replies to our issues or questions raised at our last meeting held on the 17th of December. So that's paper number 671-01, and the administration's reply is in CP bracket 1671-02. And the Secretariat staff has reminded me that we will have to follow the agenda in conducting our meeting. All right, let's wait till the administration team has joined us. With us today, Mr. Lai from the EPD, Mr. Andrew Lai, Mr. Samson Lai, Assistant Director of EPD, Ms. Selina Lau, Senior Government Counsel, and Ms. Libera Chang, Senior Administrative Officer. And with us is the minutes of the meeting held on the 8th of November 2013, paper number CB bracket 1644. And according to the Secretary, we have not received any proposals for amendments. So are there any proposals for amendments here and now? If you have any proposals, please do make them known now, or else we will confirm the minutes. As I said at the outset, we had two papers with regard to the follow-up actions taken after the meeting held on the 17th of December. And we do have this list, and the administration has responded accordingly. So I'll be giving you time to look into this. So to save time, Mr. Lai, over to you. Please let us know or walk us through the reply by the administration. Yes, thank you, Chairman. At the last meeting, members asked 5 questions in total, and we have now come up with our response and stance in a paper. First of all, A and B, they are related because as members were concerned that after the implementation of the second stage PSB levy, well, for large organizations, they do not have to report and also submit the revenue from the levy like what they were required to do in the first stage, and that's why members would like to know, with the expanded program for the institutions or organizations, to what extent have they been able to cut down on the use of plastic shopping bags, and they're also concerned about how the effectiveness can be measured. And when we went back, we also took a further look into the ways available for us to monitor the use of plastic shopping bags. We believe that the most effective way to do it is to look at the survey that we conduct at the landfills. And I understand that during the holidays, some members have also gone to site visits at landfills and see how we conduct the landfill surveys. In Annex A, according to the landfill surveys, every year we do classify the refuse into different categories, and we have statistics. And with regard to plastic shopping bags, we do have an estimate or projection on that, and we have been doing a very detailed job. For example, in the first stage, under the PSB levy covering supermarkets and convenience stores and so on, well, our colleagues did a very detailed job in the sense that they went to the landfills and they would look at the brands that are printed on the plastic bags and so on. And then we believe that by continuing with this well-established practice of conducting landfill surveys, we should be able to know exactly the number of or volume of plastic bags being disposed of at landfills, and also the trends of use. I think that's a very systematic and comprehensive survey. And of course, we have considered if there are alternative ways of allowing us to have a better idea as to the consumption of plastic shopping bags or the use of PSB. And as you can see, the CNS department and the C&E department would also look at the export and import and export of certain items, and there needs to be manifestation. Yes, Hong Kong does not impose any tariff, but then it's done on a voluntary basis. But then if you look at the over 3,000 items being declared with the C&E department, there are 2 items which are particularly relevant to this. And if you look at the classification codes, it's 83199 and 89311. So concerning these 2 codes, if you look at the trends in the past few years, well, under Annex A and Table 2, you can see that, well, for 83199, we're referring to travel goods, handbags, and similar containers. So that's included. And according to the Census and Statistics Department and also the C&E Department's survey, during the past 5 years on average, we are talking about some 400 to 800 million items being imported. And of course, that might not be the best estimate, because that would also include travel goods and also handbags, and also for packaging materials, it just constitutes one of those materials. And also for the 800 million items, what when compared to the 4 to 5 billion items being disposed of at landfills, is a drop in the bucket, and therefore that might not be a very good reflection of the actual use of plastic bags. But then under 89311, that would include sacks and bags for the conveyance or packing of goods or plastic. That would give us a better idea. But then it's somewhat interesting here, because according to the C&E department and the CNS department, they only have the total value of such items being imported without the actual volume or quantity. That's why this may not be a very effective way of showing the trend. And if you look at the amount, that would be about 1.5 to 1.9 billion dollars during the past 5 years. So we try to see if there are better indicators to show the import and use of plastic bags in Hong Kong in the past. But then according to the C&E department and the CNS department, apparently our landfill survey would be a more comprehensive and systematic way of finding out how many bags are being used. We can promise that once the scheme is expanded, we will continue to do this landfill survey in order to monitor the change in the pattern. And item C, I think it was raised by Mr. Vincent Fang last time. He referred to the different scenarios. For example, if I buy a bag of candies, do I have to pay for the bag containing the candies? And then in Annex B, we do have this illustration with the pictures and everything. So that would also explain the circumstances under which the levy will be charged. For example, if you buy a pack of candies, if it's already prepackaged and if it's independently packed, then if you have to put on another plastic shopping bag, then a levy will be charged. But then it's like figure 3, as members suggested. If a confectionery seller provides a carrying bag that resembles the other confectionery packaging, then the carrying bag would be regarded as a bag. And that's what we explained to the Bills Committee last time. And then under D, at the meeting earlier, we submitted the government's proposed CSAs. With the commencement of this bill, we'd like to explain the commencement date and also the other support measures. We try to set it out clearly in the bill. That would also mean that this council will no longer be required to scrutinize another set of bill or regulations, and that would also expedite the implementation and help us with the publicity and education. Because when we explain to the small vendors that stage 2 of the PSB levy scheme is coming, then they would have to understand better as to the circumstances under which this levy will be charged, and they would also be very concerned about the commencement date. Once this amendment bill is passed, and if we have to wait till another bill is presented before this council before we can implement that, and then we can tell the vendors and retailers as to when this is going to be implemented, then that might cause some obstacles to the implementation of this. If we are able to tell them what this is all about and when it's going to come into effect, then everybody will be able to work towards this. So I hope that members will accept our latest proposal with regard to this CSA, which will incorporate the commencement date and also the dates for the relevant provisions of the relevant schedule. So that would enable us to implement everything in one go. And we have also sought legal advice on E, assuming that the Bills Committee is able to enact this bill by March, that is the first quarter. Assuming that everything is done smoothly, then we will take another 12 months for the preparation and for the conducting of publicity and education, and then the 1st of April of 2015 will be the relevant commencement date, and we'll try to put that in the amendment bill.
E is about the penalty. In the first stage of PSB levy, in case of an offense, we would issue a summons, and the relevant operator or trader will have to attend a court hearing, and the court will decide the level of fine. But actually, we have only got 7 cases in the 4 years of implementation in the first stage. In the second stage, we are going to cover more small and medium-sized enterprises. That's why in the bill, for 2 types of minor offenses which are not controversial, and that is to say, when a levy should be collected, the business doesn't collect the levy, or they try to avoid this. Say, if for the goods is at $10, the bag should be 50 cents, and then the business will say, I provide a rebate of 50 cents. Then a penalty, a fixed penalty, is imposed. We want to, of course, on the premise that the business admits guilt, we will allow the payment of a fixed penalty for such a minor offenses. The proposed fine level is $2,000. At the last committee meeting, some members thought it was on the high side for SMEs. We have considered this after the meeting, whether we should lower the fine. And we have come down to the decision that we should maintain this level of $2,000. Of course, the SMEs do have a choice. They can choose to comply with the law, and when they issue a PSB subject to a levy, they can collect the levy and avoid penalty. But when an offense is committed, we want the penalty to be a good deterrent. If it's lower than this proposed level, the effectiveness of the penalty will be less. So we hope that the penalty level will be a good deterrent and serve its purpose. I'll pause here, Chairman. All right, members, you may raise questions regarding these 5 follow-up items. If there's no question, then I would like to propose that before we proceed to the scrutiny of the relevant provisions, let's look at Annex B, where we are given examples of bags specifically designed for containing the goods. I believe the examples can facilitate our discussion because in previous meetings, some members refer to the shopping behavior and the way different goods and products were packaged, asking for the administration to respond to their questions, and now we have been given some examples of such bags. And if this bill is passed, of course, they will also be doing some publicity, making reference to similar examples. I think the law would just say that these are bags specifically designed for containing the goods and nothing more. So what is meant by such bags ultimately is a question of law. And I don't think people can refer to the 3 photos that the administration gave us on a certain date. So when you have undercover operations or when people suspect that there are bags which should not be regarded as specifically designed for containing the goods, and they make a report to you or they lodge a complaint, and then when your frontline enforcement officers detect such cases, and you want to put your case against the offender, then ultimately it would be for the court to decide. I don't think we can resolve this issue by just having a few photos showing some examples. Is my understanding correct? Mr. Lai? Chairman, you are correct. We can only tell you what the legislative intent is in respect of the exemption provided for bags specifically designed for containing the goods. We can only talk about the relevant principles, but in the market there are many different groups, and there are different bags designed for containing different goods. So our publicity effort is going to be challenging. And that's why we actually need 12 months to get prepared, because apart from referring to the principles, we have to talk to the relevant trades. For example, the businesses selling food items. We may have to compile leaflets for specific trades and businesses. As I have said, the 3 photos in the annex are examples. And we are not saying that everything that is used similarly will be exempted. Because in the future, there may be people who are very innovative and come up with different bag designs. And whether they would fall under this exemption will be subject to further examination. And there are two hurdles here. First of all, it's going to be enforced by EPD officers, and we would only do prosecution, carry out prosecution if it's considered that the relevant provisions have been breached, and if the business operator pleads guilty, and then there will be a fine, and if he pleads not guilty, then it will be for the court to judge whether the particular provision has been violated and an offense committed. So we would be dealing with controversial cases, I'm sure, in respect of the definition of such bags. I want to ask a question about the 3rd photo. is talk about a bag specifically designed for containing the confectionaries. But here we're talking about something conceptually prepackaged, like this bag. If there's no holding place, no handle, and the design looks like it's specifically designed. But if there's a handle, or if a string is attached, it can be more complicated. So the question is whether the bag is specifically designed for those goods concerned. In the confectionery shop, you may have biscuits, candies, and other goods. You may have a big bag containing different groups, and it can be controversial. So how do we look at the legislative intent? It should be a simple matter. If it's a prepackaged food, and if we put it in another bag, so unless it's prepackaged, or the bag is specifically for the goods concerned. So a particular size of will be for certain particular sized goods. So for EPD officers, for businesses, and for the public, when it comes to the photo in Figure 3, it can be a difficult decision to make. People may claim that it's a special bag. So how do we assess whether something is covered by the third photo here? Because people may try to exploit different loopholes. Well, last time Mr. WU Chi-wai asked us to further explain why we thought the bag he had shown us would be subject to the exemption. We look at the type of goods. These are candies individually packed. It's a common practice, and also it's reasonable. But at present, we don't have a lot of traders packing biscuits piece by piece. But for candies, it's a common practice. But some would sell such candies by weight. And other goods don't use similar practices as commonly. Some are individually packaged to the extent that they would not be exempt under the hygiene legislation. So we'll look at the type of bag involved. In photo 3, figure 3, you look at the size, and the design is similar to the one in photo or figure 1. It's not that they are trying to provide a mega-sized bag in disguise. So figure 3, the bag shown in figure 3 can exempt the exemption. And a bag is a container, whether it's a special design, the bag can contain these candies and other things and other goods. So we'll see if there are other goods involved or whether the same justification can be satisfied. Say if it contains lemon tea, a pack of lemon tea, or a can of soft drink, and then the analysis for candies would not be applied. Dr. Lo Wai quote, if I apply common sense, say you are saying that a trader would resort to a lot of means to give the customer a plastic bag without charging him. Why should the trader be doing this? He could have just collected the levy. But in the gray area, where a levy is or is not chargeable, then that's the area of concern for us. I would like to give you some examples and grateful for your response. For example, if the candies are sold by the pound, by the weight, and if the customer is given a plastic bag which he can reuse from an environmentally friendly perspective, it's good. You should not instead ask the customer to pocket the 3 pieces of candy instead of putting them in a plastic bag. So the practice should be allowed. And if a levy is chargeable, the seller and the customer may not regard it reasonable. If you say that you have a specially designed bags with some logo and design printed on it, well, it's exempted. But actually, the two bags serve the same purpose. So maybe there are different goods containing in a so-called goodie bag. You may say that this bag is specifically designed for the goods contained, with biscuits, sweets, and other goods contained in that bags of for goodies. Would you consider that as specially designed? Thank you, Dr. Lo, for your questions. I think we share the same ideas. The plastic bag given to a customer costs the seller something, so there's no incentive for the seller to provide it free of charge. But if we impose a levy, that the seller should collect the levy, is in their interest.
So as the chairman just said, well, in the law, we can only go as far as stating the purpose of the law and also the general picture. But then in terms of the actual arrangement, because we do have the detailed arrangements in place, if we say that under no circumstance should that be exempted, then of course that would be simple enough. But then in coming up with this bill and also in the course of deliberating and discussion with the Bills Committee, apparently this is a generally held view. That is where there are hygiene concerns, where there are some very common practice by the retailers, and they are regarded as reasonable use of plastic bags, then we should face up to this situation, which is already happening on the ground. That's why in coming up with this arrangement, we also have to bear in mind such circumstances. That's why with the exemption mechanism in place, and in the future there might be different scenarios. For example, Dr. Kwok also referred to the situation of fortune bags and so on. Of course, there are bound to be new circumstances arising. I think all we need to do is to look at the bill or the law, and then to look at the circumstances on a case-by-case basis. Yes, there are two aspects here. On figure 3, we are not saying that, well, given the fact that there is a handle, and also given the fact that there is a brand name on the surface of it, then there will be an exemption. But then we will have to look at whether or not this is for the general purpose of carrying the candies. Whether or not there is this brand name, there will be exemption. So we will provide further information to the retailers as to what kind of bag is used, because the original intention is not to require them to print the brand name or shop name on the surface of the bag whenever it's used to carry the candies or confectionery. Alright, if you're talking about candies which are sold by weight, then if there is a carrying bag, then that would be exempted. Yes, because if there is this flat top bag, or even if there is a handle, if it's for the purpose of carrying the candies that are sold by weight, then of course it's okay. How about the fortune bags? Well, in the first stage, the reason why we have such exemption arrangements, that's because after the implementation of stage 1, some of the department stores have made inquiries with us, because some of these items are already prepackaged. For example, more common examples are that, for example, there might be a wind breaker, and there might already be a bag containing it. Well, I think for fortune bags is similar, because if you look at the substance of the item, there might be different items being carried in a bag. But then even for the containing bag, it's also part of the item being sold. So that's also why we have come up with this definition, specifically designed for containing the items. Well, with that, I'm more reassured. I can put my heart at ease. I think that's more reasonable. But then in your publicity efforts, you will have to make sure that both the merchandisers and the customers will understand it, because we have to make sure that there is no dispute whatsoever. You are not trying to deliberately charge this levy. Once there is this argument as to whether the levy should be imposed, that would be problematic. So you have to think about it. Well, if we have to spend so much time when we discuss this in this council, then it might be even more difficult when you try to inform the consumers. Alright, different members have come up with different scenarios. I'm sure in the actual implementation, as you can see from the timetable, you can also help the administration by asking questions. Would that be a sufficiently long period of time for the administration to do the publicity and education campaign? Can I ask further questions? Yes, of course. Alright, on A, you talk about the statistics. I believe that the statistics are very interesting, and indeed, they might illustrate certain situations. Under the levy scheme, before and after the implementation, the drop rate was very significant. So over 600 million now is a lot lower. So you're going to do it further. So how are you going to interpret the phenomenon? And also, if you look at the figures, well, I think we should support it, because the earlier experience shows that it's been effective. I hope that the statistics will speak for themselves, because if you look at the large quantity of plastic bags being dumped at landfills, there has been no improvement whatsoever before the implementation of this scheme, and now we have seen some genuine reduction. And in the past, we did have a lot of skepticism about this, but then we did pay a site visit to the Sha Tin treatment plan. All right, when you look at how they classify the different categories, you can see that they have been doing a remarkably detailed job. Well, many people might also have such skepticism. I think you should educate the public so that they will have a better idea as to what you've been doing. Mr. WU Chi-wai, I'd like to ask the administration to answer this question. All right. You're talking about the number of plastic bags. We're talking about 4.5 billion, and then all of a sudden it shot up to some 5.2 billion. Yes, this is just an annual trend. So there was an increase by 700 million. So how do you interpret this increase? By 2012, the number of PSBs disposed, we had 5.2 billion. So why did it all of a sudden shoot up to such a high figure? Well, as Mr. Low just said, through the levy, we'd like to change consumer behavior, and we noticed that after the implementation of phase 1 of the scheme, there was a significant drop. So that's good. But I'd also like to take the opportunity to remind Mr. Low that is by 2010, 2011, and 2012, apparently the figure plateaued. I think all right, there are two insights that we can read from that. All right, the intention is to change consumer behavior, but of course, for those who are prepared to change, then of course they have changed. But then there are bound to be some people who think that I can afford to pay the 50 cents, and therefore I cannot be bothered. And if you look at the retail volume, in fact, there is a rising trend. That's why, well, with more items being sold, the use is bound to go up. So that also has to do with the retail volume. That's why, Mr. Wu, your observation that by 2012, in the landfills, if you look at the number of PSBs being disposed of, all right, all of a sudden it went up from 4.5 billion to 5.2 billion. And all I can say is that we have only reported to you the facts. And we did not know whether or not this is the trend or whether or not this is just incidental. But then apparently, with the growth, or there are some external factors affecting this that may not have to do with the spending pattern in Hong Kong. For example, if the retail volume is going up, for example, in 2013, if we have 50 million visitors coming to Hong Kong, and of course they might also be taking with them plastic shopping bags, but then for some, after buying certain things, they might just dispose of their bags here in Hong Kong, and that would also affect the disposal rate at the landfills. So they might be the reasons. So we will have to monitor the situation for a couple more years before we can really tell whether or not this is in fact the case and what the reasons are. Mr. Wu? Yes, basically I would agree with this projection or inference. But then with the robust retail sector, of course that might be the case. And if what you said was true, then there should have been this rising trend instead of just having this shooting up to 5.2 billion all of a sudden. And then even starting from 2009, with more cities opening up, I think the trend of the number of visitor arrivals has been growing, and if it went up by 700 million, I think it warrants your greater attention. You should look into it. When we discuss this bill, we have never had the intention of changing the retail sector's approach. We have never expected a sudden change. But then, as you just said, what we do not like to see is that you might have difficulty in your publicity, or you might have difficulty in your enforcement efforts, because some people might be caught inadvertently by this, because they might not have an idea as to what would constitute an offense or what. Alright, they also have flat top bags, and to a certain extent, well, for some of their regular practices, they are just doing it as they were used to, and then after, and of course you have to pay the levy if you ask for an additional bag. But then for these flat top bags, people might have used it to carry certain items, whether intentionally or not. But then it's difficult to make any observation of it. So even if there is a registration system under stage 1, I think this arrangement would still result in people resorting to this practice. So at the retail level, well, once you have such arrangements, naturally, people might resort to such behavior in response to such arrangements. Well, I'd just like to clarify this, because precisely on A and table Annex A and Table 1, you talk about the landfill surveys. Alright, for the plastic shopping bags from the 3 retail sectors that have been affected by stage 1 of the scheme. In fact, there are still plastic shopping bags that are outside these 3 retail sectors. For example, they might be shopping bags with or without the name of the shops. So how do you distinguish between that? Well, we will have to be a little more detailed in this. Mainly, we look at the shop name. We will distinguish between supermarkets and also convenience stores, and also personal care, cosmetics, bags, and so on. So these are the retailers covered by stage 1. And then for bakeries, bookstores, and also electrical appliance shops and so on, there are also different categories. And then for the SMEs and wet markets without any specific shop names, we will classify those as miscellaneous, so we will have no idea as to whether or not they are from the wet market or from the metal stores. But then I refer to the 3 categories. Some of them might have shop names, others might have the brands of the cosmetics and so on. So there might be some difficulties doing the classification. Indeed, that's true. Alright, in terms of the sampling and also in terms of the way adopted in conducting the statistics and so on, I think some members who have been there at the site visit in Sha Tin, I think the experience should be shared with other panel members, because on that occasion I was also not one of those there. So I think we would also like to learn from their experience.
Ms. Ito, over to you. Well, why didn't you go? That would have saved us another item for a fresh discussion. Well, there may be different plastic bags. Some are better built or beautifully designed, but with the levy imposed, bags are becoming thinner, rather like the garbage bags. The supermarkets or the red flat top bags used in the markets are commonly used to contain refuse. But there's no such breakdown in your assessment. According to Friends of the Earth, it's not a bad practice to reuse plastic bags. We have 2.7 million households. If all these families, these households, use these plastic bags, then they don't have to buy garbage bags. But the premise must be that the supermarkets use a thin plastic materials so that these plastic bags looks like or are built like garbage bags. There are now more PSBs disposed. Maybe it's because of more tourists under the IVS, and they just dispose of bags. In the second stage, you cover not just plastic bags or bags made entirely of plastic, but also bags containing plastics. You have to change the bags issued by retail shops because they use very good material. The cost can be a few dollars. There's no need to have such a strongly built plastic bag to contain an item of clothing or few light goods. All right, if members have no further questions, then we can wrap up our discussion on the 5 follow-up issues. Mr. Wu Chi-wai, I've heard from the Assistant Director that they have very detailed breakdown figures. I'm interested in getting the information because basically you have been saying that it's categorized into those with labels and those without. Well, if you want to follow up issues in detail, members may wish to take it up in the panel, in the future panel meeting. And further views on the bill are always welcome. I thank the member for the comment on the landfill survey. I'll inform my colleague of her view. Actually, we have 10 categories in our survey. We can provide information to members for reference. But I would like to sound a word of caution. In the second stage, can we achieve a drop of 90%? Well, that may not be achievable because we have 4 billion bags disposed or used. Some come from the catering trade, 300 or 400 million, and we have exempted these. So it's unlike the first stage, because when you go to a supermarket, a shop, you can bring your own bag. It's usually pre-planned, pre-arranged. But when this is extended to the retail sector as a whole, it's not really it's really uncertain whether we can also achieve a reduction of 90% because we would have covered the catering tray as well. It's CB 1557 13 to 14 bracket 01. We have a paper containing the government's CSAs. As Mr. Lai has said, these will contain provisions for implementations, commencement days, and they would like us to enact these so that in the publicity they would be able to inform the stakeholders. So, members, would you like to handle these CSAs first? Because in principle, we can do the cross first. The paper is dated the 18th of December. I'll ask my colleague, Ms. Zhang, to take us through the CSAs. There are 4 annexes. We have to cover A and B. We can look at C and D now. It's about the actual operational provisions for the PSP levy. It's a 653A requiring businesses to get registered. So Annex C is relevant here. There will be amendments to Cap 603, seasonal returns, levies, and so on and so forth, which will no longer be applicable. And we propose to repeal all these. And then Part 6, fixed penalty, notifications, certificate, and how to pay the fixed penalty. These are to facilitate the operations. So there will be provisions on where you can pay the fixed penalty and what kind of form can be used. Here, we have reference to other environmental friendly legislation, such as the ban and the penalty for idling engines. And we have also provide some sample forms for members' reference. So that's all for Annex C. Members, comments? Please continue. Let's go to Annex D. May I invite members to refer to Annex C of today's paper. The content is the same, but it's clearer in its current form, because the commencement date of the 1st of April 2015 have been included. With this commencement date, then we know when other provisions will be implemented or will commence. So let's look at Annex C of today's paper. Annex C are all transitional provisions. Before the new commencement date takes effect, the 3 categories, specified categories, will continue to apply. 3,400 businesses may have to file the last return before the commencement of the new law. So for C, we have specified the commencement date as the 1st of April 2015, and that is a premise on the passage of this bill enacted by March. We need 12 months of preparation, so the new ordinance will come into effect on the 1st of April 2015. And that would tie in with this the quarterly returns submitted by existing retail businesses, because they do this quarterly, and there will be no need to adjust the days for filing returns. Division 6, savings and transitionals. They are also for implementation. And then we can proceed to Schedule 5 in Annex C. There are savings and transitional provisions And we'll be talking about pre-amendment and post-amendment dates. There's some highlighted dates. For the 3,000 odd businesses, they will be required to submit the last return, and we will talk about what we mean by the last quarter and when they should submit their returns and when the due date will fall. So for these businesses, they can refer to Schedule 5 and know all the days, and they don't have to figure out what they should do before and after the new ordinance comes into effect, and then they can comply with all the provisions. And most of these are operational provisions in Cap 603. It will be easy and problem-free for those who are covered in the first stage if they refer to Schedule 5. For record purpose, please tell us the relevant dates. Commencement date is the 1st of April 2015. And what about the transitional provisions? The chain stores will be required to submit returns. When will those returns be due? Please tell us the dates. Thank you, Chairman. In Schedule 5, the commencement date is the 1st of April, and in Section 2, we're talking about the last period. Bracket 1, returns on payment of levies due after that. The last period means the period beginning on the 1st of January and ending on the 31st of March 2015. That would be the last period for which returns should be submitted. The thousands of businesses covered in the first stage will submit the last return during that period. The last period is from the 1st of January to the 31st of March. According to the existing arrangements, they have to submit the returns within 30 days. And they have to inform the administrations how many plastic bags were issued in the quarter and how much is payable. And it means that they have to submit the last return and the last levy amount before the 30th of April 2015. Please continue. Section 3 is similar to Section 2. Here we're also talking about the last return. The cutoff date is the 30th of April, and the levy should be payable by that date, and then there will be a penalty if they fail to do so. The penalties are already in the existing law, Cap 603. Next section is about record keeping. Under the existing ordinance, the businesses have to keep records of plastic bags issued and how many bags were subject to exemption and number of bags imported, etc.
So there are certain forms requiring them to keep the records for at least 5 years. For example, under the existing arrangement, let's say on the 8th of January, I'll have to keep the record until the 31st of January 2019. But then, as we have already set the cutoff date at the 1st of April 2015, we believe that keeping 5 years records should be okay, and that's why, with regard to the commencement date of the 1st of April 2015, and if you count data from that date onwards, then we have now put in the date of 31st of March 2020, so that's the date by which they will have to submit the return. So all they need to do is to keep the records until the 31st of March 2020, a full 5 years, and that would be okay. Please move on. And then 5 and 6 and even 7 and 8, they are all related to existing enforcement arrangement. Or if they fail to pay, or if they have omitted certain information, or if they have filed wrong information, and if we have to charge them for that, or if we want to make them pay back, then basically we have now set up a date. That is, if it's before or after the commencement date, certain offences will be dealt with in a certain manner, and if you have to pay it back, then what the arrangement is going to be like. So that is to align with the existing arrangement. Basically, they are the same as the existing arrangements. And then it's about certain specified forms under item 9. So we specify certain forms for them to fill in, and these are the proformas to be prescribed. So they are the same as the current ones for the 3,000 plus entities that are used to the existing form. So all they need to do is to complete their statutory duty by filling out the forms and submitting them to us. So you said that with the commencement of the new law, they also have to keep the records for 5 years. So they will have to do it for at least 5 years, because they do have the responsibility to submit the returns, and they will also have to pay within 30 days after the submission of the returns. But then if they have failed to do so, or if they have furnished incorrect or incomplete information in the returns, then they will be punished. So we have this 5-year record keeping requirement, and the deadline is the 31st of March 2020. Yes? For the 3,000 plus retailers, or the 40 registered retailers, what they need to do is that every quarter they will have to report to the administration as to how many bags have been distributed and how much they have received, and they will have to pass it on to the administration. And then the dates would be the 1st of January, 1st of April, and the 1st of September. And the responsibility is that within 30 days of the expiry of the deadline, they will have to submit the returns and also make the payment. So these are the two milestone days. First is about the submission of the forms and the returns, and within 30 days they will have to make the payment. And if they fail to do that, then there would be there would be consequences. For example, they will have to pay the surcharge and so on. So we have elaborated on that, and that's the situation after the 30th of April. That's consistent with the present arrangement. And we also have the record keeping requirement for 5 years, and now we have specified the date, and that is until the 31st of March 2020. So all they need to do is to keep records until that date. And then we can also see that under 3, with regard to surcharges for offences in respect of payment of levies, we do have a typo in the Chinese version. It should have been the 1st of April instead of the 30th of April. So the English version is correct, while the Chinese version will have to be amended. So we will have to double check. But then on the whole, 1st of April is the deadline for the submission of returns, and then they will have to make the payment by the 30th of April. Alright, I hope that members will understand this, because if you want the Bills Committee to do something additional, alright, it's not supposed to be our duty, but then we will try to help out. But then for the rest, it's more or less like, well, just trust me. So these are the dates, and then please do think about how it's going to impact upon the retailers in the first stage and also the consumers and so on. So please do be very careful about the dates, because it's going to affect those who will be affected. Yes, any comments? Legal advisor? Thank you, Chairman. This might be textual or just typo. Alright, if you look at the English version, first clause, interpretation, section 1, bracket 14, extends to any other provision, and in the latest version of that ordinance or the PSB regulation. But then when I looked at the earlier version, according to the information and the electrical brief that you submitted to this council, when I looked at the marked up copy, is this ordinance instead of that ordinance. So can you clarify which is correct, this or that? It should be that. It should be that. DFJ colleague, yes. That refers to the pre-amended ordinance. So all we need to do is to follow the latest English version. Yes, correct. Another point about implementation, so please do help us with that. Looking at the same section, section 2B, 2B, during the transitional period, the applicants can apply to be registered or apply for deregistration. With such information available, he will have to fill that in the return. So my question is, if there is an applicant who's of the view that the director, in making the decision of not allowing him to register or deregister, then what can he do? What's the existing arrangement? So can you tell us more about this? This is not just a legal issue, it's about a policy matter. So please do let us know. Yes, Chairman, for the individual registered retailer, whether or not they would like to get registered or be deregistered, they will have to apply to the director for doing so. And with regard to the appeal mechanism under the existing provisions, if the applicant feels aggrieved by the decision of the director, he can submit or file an appeal with an appeal board. Mr. Lai, can you accurately point out as to which provision will apply? How come I am asking this? That's because I've noticed that under the blue bill, actually the existing section 13, which is supposed to deal with appeal mechanisms, and then under section 13(2), if anybody feels aggrieved by the decision of the director in refusing registration or deregistration, then he can file an appeal. But then in the blue bill, you have crossed that out altogether. And in its place, you try to prescribe the matters for which they can lodge an appeal. So you talk about an appeal that may be made under the section. So theoretically, that would be able to deal with all appeals. But then when I look at Schedule 5 that you've prepared, apparently I've not been able to find out the appealable matters which can cover this, and also under 17 is about Cap 603A about the registration. I think the administration does not intend to go further with this. That's why they have just crossed it out or repealed it altogether. So, if what I said happened, then what can he do? And what are the appeal avenues? Who can answer this question? Well, first of all, let's look at the provisions, and then for the policy issue, I think my colleague can supplement. Well, under the existing 603A, that is the Product Eco-Responsibility Ordinance, well, for anybody who would like to get registered or who would like to be deregistered, if anybody feels aggrieved by a decision of the director, then under Section 13, he can lodge an appeal. And this appeal, under the bill, that is, if that should happen before the 1st of April 2015, then under Cap 1, that can continue to be dealt with under Section 13 or the existing provision. With regard to the right to appeal, well, under Section 23 of Cap 1, he can continue to lodge an appeal, but then if the right to appeal, for example, if he has had his application rejected, but then if the administration has yet to make a decision which might make him feel aggrieved, then after the 1st of April 2015, then he will no longer enjoy this appeal right, and we do not have any saving clause. But then from my perspective, because after this data, this is no longer the case, and therefore there is no point in keeping this provision. Well, if you look at the provision, that will be the result. That will be the end result, because there is no such a mechanism. That the registration mechanism will no longer be there, and therefore the decision has already been made, and therefore under Cap 1 of the laws of Hong Kong, Cap 603 will continue to apply, and then they can just continue with their normal business. So, is there a need for the administration to go back and think about it? We will have to look into it. That is before the 1st of April, if everything is ready, if everything is done, then the appeal right is already there. But then if we have not been able to deal with that, for example, if they have only been able to submit their application or file an appeal on the 31st of March, then what happens? Well, for these retailers, when they make an application, there is a certain pattern. All right, there are new shops opening and there are shops being closed. So how do we deal with them? And if it's a technical matter, let's say if they only submit their application on the 31st of March, then what should we do? Do we need to have a transitional clause, or do we have to coordinate with the retail sector on that? We will have to look into the actual situations. Well, it might be better if we resort to coordination with the sector, because if this is allowed to drag on, then the transitional arrangements will be even more complicated.
Please do consider the way forward. You may want to opt for the better communication or administrative measures to deal with this so-called vacuum. It's just a small vacuum area. It's not really a serious matter, but suffice it to say that there's still some holes to be plugged. Legal advisor, I want to make one further point. In Cap 603, Section 20, the director has to maintain a register. But in the new Schedule 5, there are no further provisions to ask the director to maintain the register. Would the administration please confirm or clarify this? After the last quarter concern, the relevant retailers still have the legal responsibility to submit further information pertaining to the past. But it seems that the director doesn't have to maintain the register, or if he's going to maintain the register, how is it going to be done? It seems that the director doesn't have to maintain or keep the register under the new provisions. And if that's a problem, how is it going to be handled? The retailers have a responsibility to do something. But what about the director? In the first stage, we're only talking about 3,000 retailers for which the levy scheme applies. So Section 20 serves the purpose of informing the public which retailers will be charging the levy. Yes, that's under Section 20(1). The director has to maintain the register for public inspection. In the second stage, this is no longer relevant. As for whether we are going to destroy the register and then we cannot take follow-up action in enforcement. Because we know which retailers are covered in the first stage. I know that when it's fully implemented, you don't need to register anymore. Because the retailer has the right to apply for registration or re-registration, and they may want to take out past information in the register. I don't know whether they would consider litigation and so on and so forth. I wonder whether you are going to have any provisions to deal with that transitional period in relation to the register or documents maintained. You may want to clarify the position through further provisions or through policy announcement. If the amendment ordinance commences on the 1st of April 2015, then for the 40 chain retail stores, they will have to submit the return in the first quarter. And they have to tell the director changes in retail outlets. For example, in the first quarter of 2015, a supermarket has opened a new branch. Then the retailer, the supermarket, has to inform us. So for such transitional matters, after the amendment ordinance comes into effect on the 1st of April 2015, should there be something to wrap up past returns? For example, should we be updating the register up to the 31st of March? We'll consider in what way this can be done. We'll consider ways to inform the public and also to ensure that we keep proper records. And that is at the close of the first stage, the 31st of March 2015, how things stand. We think we need to give an account on what the situation is like at the close of that stage. Okay, perhaps you can also give us some information in writing. And there are certain matters concerning the transitional period. And you may wish to deal with certain matters through further provisions or policies. It seems that there are certain legal liabilities which would survive the passage of the bill, and you may wish to clarify how such matters are going to be handled. Further questions from members? So I think we can pause here in relation to the cross-by-cross examination. Mr. Wu Chi-wai, a member of our Bills Committee, has also proposed some CSAs. And we have been given some documents. It's CB 1, 5, 8, 7, 13, 14, bracket 01, from Mr. Wu Chi-wai. And after the last meeting held on the 17th of December, Mr. Wu might have communicated with the administration. Let's have an update from the administration. Mr. Wu Chi-wai is concerned that after the implementation of the second stage of PSP levy, the government would adopt some means other than the landfill survey to ascertain the usage of PSPs. Well, we have referred his views to the Retail Management Association, but it was during the holiday. So some of the responsible people were on leave. We'll talk to the association to see whether they can do something to address the concern. In particular, we'd like the big retailers to enable us a better understanding and also a better monitoring process of the issue or use of PSPs. But there are some suggestions in the document. We have discussed some of them, and you may have all covered some of the others in other ways. But we hope the administration would provide a response in writing to Mr. Wu Chi-wai's proposed amendments. Let's have them by the next meeting, certainly. AOB, the next meeting will be held on the 15th of January 2014, Wednesday. Again, we start at 8:30. It's more and more difficult to get slots. We may have to advance our meeting date for future meetings to 7:30. Well, on that day, it's the policy address. So that's the only slot we can get for the next meeting. We are going to do the wrap-up on the 15th. Thank you for coming.